but objections.
Oh, yeah.
Of course, now that you said that.
No, I will never mess that up again.
No, it's
Everything
fine.
else, no
You don't
complaints,
expect
but
me
my
to make
jacket
any
will be
commitment.
buttoned.
A great sticker. You voted today.
I did.
Yay. Make sure when you're sitting at the table that you're looking like a diligent listener and that you're taking even big notes on a piece of paper so that we don't think you're staring off at mistakes or because that loses points.
Absolutely.
So, I always like it when people write down the question, even if you're not talking. It's like, oh yeah, okay, your body language.
Yeah.
You know, really.
My favorite is
bullshit
if you did
people.
this. You know, with the judge, like you're really pondering this.
Yeah.
Show some serious focus.
Or like, yeah, he made a great point.
No, don't say
I
that
know,
to the other
you
side.
can't say it. No, I'm talking about.
Oh, to your co-counsel.
yeah,
Yes. Mm.
yeah, absolutely.
Oh, I thought you were
Build-
saying to the judge.
Build up the confidence.
Give him like a thumbs up.
You tell me.
Ready?
Another
Alright.
side. All right. Go for it.
Madam Chief Justice, may it please the court. My name is Matthew Lerner, and along with my co-counsel, Elizabeth Kramer, represent the respondent in this matter, Miss Erica Wright. Ultimately, this case is one of undoing the wrongs of discrimination. First, I will show that Miss Wright has a valid Title VII claim of discrimination. Then, my co-counsel, Elizabeth Kramer, will show that Miss Wright was improperly denied leave under the Family and Medical Leave Act. Ultimately, with regards to Title VII, Miss Wright suffered adverse employment action because of her gender and sex. And for the following reasons, we ask that you reverse the decision of the 13th Circuit Court of Appeals, because first, Miss Wright is covered under Title VII, and second, Miss Wright has a valid Title VII claim of discrimination. The facts and timeline in this case show an employee who diligently worked hard to build a career at Beats, only for it to abruptly end due to her decision to transition to her born gender. Miss Wright, upon graduation, began working at Beats, and for almost a decade, Miss Wright was a successful employee who received promotions. Then, in April of 2015, Miss Wright received her first negative performance review. While still very strong overall, did acknowledge that she was suffering in a few key areas. Yet, Miss Wright, in conjunction with her doctor, continued to improve and began her transition. Almost a year later, in December, Miss Wright interviewed for a promotion. Miss Wright did not receive that promotion and was informed of such several weeks later. It is important to note that after her interview, it was then that Miss Wright informed Beats that she planned to transition to a woman and henceforth would like to be known as Erica.
After the promotion,
No, Your Honor, after the interview for the promotion that she did not receive several weeks later. And then 3 days after she did not receive the promotion, due to Beats's image-conscious nature, was transferred to a less visible role in graphic design, a department she had no training, no experience in. No longer in the revenue-generating position of bringing in sales and investors, and now focusing on content creation with minimal contact with employees as well as outside customers and investors. With
she's
that,
been very successful in this role though, right?
yes, Your Honor, which is a testament to Miss Wright's
And she wasn't
stellar.
successful in her other role.
Your Honor, she absolutely was, and as the record shows on page 31, it was in April that Miss Wright received the negative performance review mentioned by my opposing counsel. Yet it was not until February of the next year that she received a transfer to alleviate those concerns, as Beats alleges.
It seems like a very willing employer then, who was willing to let her continue in a role where she was not being successful and likely losing money if she was working on client relations.
Your Honor, there is no evidence that Miss Wright lost any revenue for the company. In fact, as shown on page 9 of the record, when Beats's customer and investor contacts were told of her decision to transition. A minimal amount stated that they disapproved, yet none of them pulled any type of financial support.
Right, but here in this situation, you're saying that she was denied the promotion, but it's not as if she was fired for the bad performance review. And in this particular situation, there was no change, no impact on salary, benefits, anything like that. So, I mean, in this situation, the employer really wanted to discriminate, would have terminated employment, or at least put her in a position that had a reduced salary. But there was really nothing that changed about her paycheck or her life, right?
No, Your Honor. However,
I should say her career. I'm not going to say her life, but about her career.
no, Your Honor. While she was subsequently terminated for different reasons, both her non-promotion and her subsequent transfer were an adverse employment action. Looking at the second issue and speaking specifically to the transfer, as held in the Seventh Circuit by Collins v. Illinois, a lateral transfer in terms of seniority and salary does not negate a claim of adverse impact. In that case, the court found that because the employee stated, just as Ms. Wright did, they did not want to be transferred to that department, and that prestige as well as perception were very important factors in assessing whether or not a transfer was truly lateral. Additionally, the Sixth Circuit in Smith versus the City of Salem, a Fifth Circuit case, that court found that a decision by an employee to inform their employer that they plan to transition, with adverse employment action taken shortly thereafter.
But there, the employee was actually terminated, not transferred, right? In Salem, the employee was actually terminated?
Yes, Your Honor, but as this court has held in McDonnell Douglas, necessary for a prima facie case is an adverse employment action, not purely a termination. And it would be a dangerous policy decision to state that adverse employment action short of termination cannot be used to satisfy a prima facie case of discrimination.
But analyzing the facts and comparing employers' discrimination, termination is quite different from transferring someone to another area.
Yes and no, Your Honor. While termination is more severe, ultimately the prima facie case does not distinguish between whether or not how severe the adverse employment action was. And in that case, the court held that temporal proximity, along with comments from the employee and felt by the employer as well as fellow employees, congruent, taken together in a mosaic, was enough circumstantial evidence in order to show a prima facie case. And in this case, as Madam Chief Justice brought up to my opposing counsel, these are issues for a jury. And that is who should be deciding these questions of fact. Looking at Smith versus Lockheed, in that instance, while it was pertaining to racial discrimination, the court found that same mosaic of circumstantial evidence, just as we see here, with comments by fellow employees, comments by the employer, as well as strong temporal proximity. This mosaic is enough to put this question to a jury.
But that's just the Sixth Circuit, right? The Sixth Circuit is a lone voice on this issue. Basically, the other circuits that have considered it, right, have decided against that. And in this situation, wouldn't we be condoning the Sixth Circuit kind of creating this unprecedented right that was never contemplated when Title VII was enacted?
No, Your Honor. There have been several circuits, as well as in the public sector, the EEOC finding that gender identity is protected under sex. The Ninth Circuit, in Schwenk versus Hartford, a case very similar to here, found that gender identity could be, discrimination based on gender identity could be analogous to discrimination based on sex.
What was that case?
Schwenk versus Hartford in the Ninth Circuit, where again, that court found that the case should be remanded to a jury to decide what was in the mind of the perpetrator.
But that case was factually different because there the focus was on whether or not we should look to the mind of the perpetrator and whether or not the mind of the perpetrator had said anything. There, the perpetrator said, I believe your opposing counsel quoted, that the individual failed to act like a man. So that's not really the same situation. That's not speaking to discrimination under Title VII for someone's gender identity.
Your Honor, to clarify, my opposing counsel was referring to the fact that that was the question posed to the jury. And as this court found in Price Waterhouse, the mind of the perpetrator discriminating against for failure to conform to gender stereotypes is sex discrimination. That court found that there was a few comments, but overall a lack of information on whether or not the mind of the perpetrator felt that the employee's gender transition, just as Ms. Wright was transitioning, was based on the fact that they failed to conform to their notion of a man. That court also went on to say that Price Waterhouse eviscerated the traditional notion of sex and has effectively bridged gender and sex to be intertwined. A district court has drawn an analogy based on the holdings in Price Waterhouse. That court found that this was analogous to a case of religion discrimination where an employer would have been fired for converting from one religion to another. That court held that to say that gender identity is not protected under Title VII would be the same as to say Judaism is protected and Christianity is protected, but an employer who converts from one to the other would not be protected. And that court explicitly stated that no court at any level has ever held that converts are not protected under religious discrimination under Title VII of the Civil Rights Act. Turning specifically to the second issue.
What was the discrimination in Price Water?
Your Honor, discrimination in Price Waterhouse was a woman was found to be not feminine enough, specifically.
So that was specifically speaking to one's gender identity, not one transitioning from one gender identity to another gender identity.
Yes, Your Honor.
And specifically, following Price Water, other circuits, including the 10th Circuit, have held that transitioning from male to female or female to male is not something that's covered by Title VII.
Your Honor, the majority of case law after Price Waterhouse has held that gender identity is covered under Price Waterhouse when there is evidence that the discrimination was based on gender. Here, Ms. Wright was presenting as a woman.
Is there anything in the record that any phrases by her employer that said she was being discriminated by gender?
Not explicitly, Your Honor. However, there is that mosaic of circumstantial evidence, such as the employer's
Counselor, stop
comments.
telling me there was a mosaic and tell me what's in the mosaic.
Yes, Your Honor. First in the mosaic is the temporal proximity. The temporal proximity shows that Ms. Wright did not face any type of adverse employment action previously. Yet after her decision to transition from a man to a woman, subsequently was not selected for a position, and then 3 days later was transferred, despite having better performance reviews than the employee selected for the promotion, and despite having more seniority and experience than the employee selected. She was then transitioned to a position she had no experience, no training in, and was substantially less visible. She was taken out of the position where she was able to generate revenue and specifically show her contribution to the company to one in graphic design, where the visibility on her and the impact of her performance on the business was taken away.
But that's not something for us as a court to decide, right? That's something for an employer to weigh. We don't know, for example, how important data entry was in the job. From the outside, it seems like it really wasn't that important. And so Mr. O'Shea actually did have reasonable qualifications to be chosen for the promotion. If we're getting into this analysis, aren't we imposing on the employer our own business judgment?
Your Honor, as seen in the Burdine case, this court held that there's a burden that shifts to the employee to show that any legitimate business reason was a mere pretext for discrimination. And that is a question for the jury. Coming off of a motion to dismiss, there is enough evidence here that there's a reasonable jury would be able to find that this was a pretext for discrimination. Whether or not they ultimately do is a question for a jury. And the standard of review of this case is whether or not a reasonable person could look to the temporal proximity, the comments that this court addressed to my opposing counsel, to Ms. Wright not suffering any, to Ms.
So
Wright.
the only things we have in the mosaic so far, Counselor, are the temporal proximity and the fact that that Ms. Wright moved from a job in consumer or customer relations and now into a role in graphic design.
No, Your Honor. Additionally, Ms. Wright was told, after informing that her image was going to change, she informed her employer that her image was going to change, and her employer then said, given Beats's focus on their image, she belonged in a less visible role. As well, Ms. Wright applied for family and medical leave for a surgery that was scheduled 2 years in advance based on the preparation for that surgery.
But Counselor, it just seems like here these pieces of evidence that you're bringing in are quite different from what happened in Pricewater, where there were specific things that were referencing gender. Is there really enough here for us to find that there was gender discrimination based on her gender identity that would be protected under Title VII?
Your Honor, I see my time has expired. May I briefly respond?
You may.
Yes, there is, Your Honor. There is enough evidence here that a reasonable jury could find comments and temporal proximity, as well as 2 adverse employment actions after Ms. Wright did not receive any employment actions, that there is enough for a jury to consider those issues. And the policy says that the jury is the one who should be the ultimate decider of facts in that situation. Thank you.
Thank you.
33.
All right, Ms. Kramer.
Madam Chief Justice, and may it please the Court, my name is Elizabeth Kramer and I represent Erica Wright, the respondent in this issue. I'm here today to discuss the second matter on appeal, how the 13th Circuit Court correctly decided that gender dysphoria is a serious health condition under the Family and Medical Leave Act, and that Beats Incorporated erred in denying necessary medical leave to an employee based on her transgender position. We ask this court to affirm the 13th Court's opinion for the following 2 reasons. First, Erica Wright's gender dysphoria is a serious health condition under the Family and Medical Leave Act. And secondly, gender dysphoria has been recognized as a serious health condition in other contexts. First, gender dysphoria is a serious health condition. The FMLA has a low bar for serious health conditions and requires only that a serious health condition involve inpatient care or continuing treatment by a healthcare provider. While some courts have held that both must be met, there is no doubt here that Wright meets both prongs. Her gender reassignment surgery took 5 full consecutive days, in excess of the 3 commonly held, and she received 2 follow-up visits with her physician and will receive more in the future. Wright's gender dysphoria is then, under the FMLA, a serious health condition.
Why do we even need to analyze if this is a serious health condition under the FMLA? Couldn't we just analyze this under depression and her symptoms of depression?
Your Honor, Wright's depression alone could meet FMLA, and certainly we can analyze it under the other symptoms, ignoring gender dysphoria, since gender dysphoria has never been addressed as an FMLA-eligible condition in other courts. In the case Schmoot v. Resort Condos International, Swanson v. Senior Resort Connection, and Clinkscale v. St. Therese of New Hope, courts rule that employees who experience anxiety and depression, who receive medication for these treatments, as Wright did, and who are directed to take time off of work from 1 to 2 weeks, depending on the case, are routinely eligible for FMLA leave. And certainly if we analyze Wright's gender dysphoria under these symptoms, as she expressed on page 18 of the record of depression, anxiety, feelings of isolation, and withdrawal, she would be eligible for FMLA. However, we can also look to courts' finding that gender dysphoria is a serious health condition in other contexts. The cases most commonly proffered are prison contexts and the tax court case O'Donovan versus the Internal Commissioner.
Isn't prison a very different experience though, because an individual undergoing some sort of transgender situation in prison would be with different individuals. They would be housed in a different facility. They would be sleeping and showering with people in a different facility. So isn't that a completely different analysis?
No, Your Honor. The analysis commonly given in prison cases is one that rebuts the old presumption that a prisoner's gender identity is frozen from the time that he enters the system. This was ruled unlawful in the prison case Fields versus Wayne in 1997, where patients who entered the prison context or system and needed gender reassignment surgery cannot be barred from receiving that surgery.
But that wasn't the only treatment for this condition, correct? Wasn't Ms. Wright managing through use of medication, and really the surgery was optional?
Certainly, Your Honor. Wright was managing her condition through the use of medication and through hormone treatment. And one could say that gender dysphoria was optional or elective in the sense that she could have continued to struggle with her gender dysphoria. However, this goes against the purpose of the FMLA. The purpose of the FMLA under 1611(1) is for employees to not have to balance their medical needs and their stability at a job. Wright shouldn't have to decide whether she wants to be employed or struggle with an easily remedied disorder. She should be given FMLA leave so she can address the disorder, solve her gender dysphoria, and return to work as a successful employee.
So now we're here. So what is the remedy that you're seeking?
Wright seeks back pay and attorney's costs, Your Honor. Moving on, in prison contexts, inmates are typically found to require treatment for gender dysphoria. While the bar here is much higher than Wright's case, because the treatment is found to be based on one that violates cruel and, Eighth Amendment issues, Your Honor. Cruel and unusual punishment. To say that someone not receiving gender reassignment surgery would be cruel and unusual punishment, which is said in Norsworthy versus Beard in 2015, is certainly a higher bar than to say that an employee not receiving gender reassignment surgery would be acceptable in society if it's cruel and unusual punishment to deny it to someone who has broken the law. Here, Wright's gender dysphoria is treatment for...
Counselor, I want to go back to what you stated earlier about seeking back pay and attorney's fees. The record also indicates that Ms. Wright has requested punitive damages.
No, Your Honor, I don't believe that's the case.
So has Ms. Wright withdrawn that request then?
Yes, Your Honor, so far as I know. Here, Wright seeks fees based on her unlawful termination stemming from her FMLA claim. Gender reassignment surgery is a very serious surgery.
Let's just assume that we go with you on that. Let's just assume that we say this is a serious health condition that merits coverage under the FMLA. In this particular situation, that really wouldn't have made a difference, right? Because Ms. Wright didn't return to work within the period of time that her doctor certified for her to be out for work. So in this situation, we can agree with you completely. We can agree that in the future, people like Ms. Wright need to be covered by the FMLA. But here, Ms. Wright has a fatal flaw to her case, right? Because she didn't return to work within the period of time her doctor told her was appropriate.
No, Your Honor. Wright's doctor told her that she could get out of bed 1 to 2 weeks after surgery and resume her normal daily activities. There is, of course, a decided difference between normal daily activities and essential job functions, especially in a high-paced job like one at Beats Incorporated. He also told her that she would begin to feel like herself again 3 to 4 weeks after the surgery, as noted on page 16 of the record.
But feeling like yourself isn't a requirement to go back to work. Many people go back to work when they do not feel like themselves.
No, Your Honor. The requirement to go back to work is a doctor's note certifying the employee is ready to return to work.
But the record doesn't have anything about a certification to return back to work or anything saying that she needed to be out 4 to 5 weeks.
Dr. G submitted a certification saying that Wright would be out for approximately 5 weeks on, I believe, March 8th, when Wright was asked to submit a medical certification and did. Presumably, the follow-up note saying that she would be all right to return to work never came into question since she was terminated 3 weeks into her planned 5-week absence. However, Wright informed Beats of her plans to take leave for this surgery far in advance. And Beats decided to let her know that she was unapproved for FMLA surgery a day after she had already had it, following Young's assurance to Wright that she shouldn't worry about the particulars of her claim and that he would get back to her very soon, which he never did in person, even though they had a close working relationship.
Does the record reflect that anyone at Beats, that there's any reason for this delay? Does the record have anything in there about referring the matter to the legal department?
Yes, Your Honor. Beats referred the matter to the legal department since gender dysphoria has not been addressed as a valid FMLA claim. However, in Beats's employee handbook, they list that in the event of uncertain claims for FMLA leave, the policy should be for Beats to provide a second or even third opinion from their own chosen physician and to pay for it themselves. Although Beats had plenty of time, they chose to not enact this measure and instead to wait until Wright had already begun her gender reassignment surgery in order to tell her that it was unapproved and then expect someone who had recently
Should she have undergone her surgery and continued the process if she did not know if it was unapproved? Isn't the responsibility on her not to get up and leave before she knows whether or not she's going to be approved?
Your Honor,
This wasn't like a life-threatening emergency. She could have simply postponed her surgery.
while it wasn't life-threatening, these very extensive surgeries are difficult to plan and difficult to plan for in cost. Wright needed the surgery, and she needed to align her gender identity in order to cure her gender dysphoria. She had been assured that her FML leave would not be an issue. She gave all of the paperwork that Beats asked her for, and she even submitted emails to follow up on it. I believe Wright was under the impression that her FMLA leave would be granted in accordance with the conversation that she had with Young on March 8th.
Now, Counselor, you just stated you believe what impression your client was under. Is that anywhere in the record that that's the impression your client was under?
No, Your Honor. Wright was told by Young that she shouldn't worry about her FMLA leave. However, the question presented for the court today is whether gender dysphoria is a serious health condition and one that requires FMLA excused leave. Here, since it meets both prongs of the FMLA's leave policy, that Wright required inpatient care and continuing treatment based on an incapacity stemming from a serious health condition, the treatment therefore, or the recovery therefrom under the Department of Labor regulations, she was eligible for FMLA leave for her gender dysphoria. Any reasonable jury could find that gender dysphoria is a serious health condition, and based on this decision, this court should affirm the ruling of the 13th Circuit Court. This court is not required to find that gender dysphoria is a serious health condition, only that it could be in order to affirm the ruling of the lower court.
Even if we view that sometimes gender dysmorphia could be some sort of gender identity issue, could be considered something covered by the FMLA leave, would it be enough that she has gender dysmorphia, or would we require something greater, something like a something more serious symptoms to be covered?
Your Honor, gender dysphoria doesn't always require serious treatment and may not always require gender reassignment surgery. And it's likely that if it didn't, it wouldn't fulfill the prongs of requiring inpatient care and continuing treatment.
Well, here it seems like in the FMLA that the things listed are things like nerve issues and mental conditions and panic attacks. These are not things that we see exhibited by Ms. Wright.
Your Honor, nerve conditions are actually similar to the conditions experienced by Ms. Wright in that they are both DSM-5 mental conditions. Nerve disorder has been updated to panic attacks, which you can see relates quite heavily to anxiety and depression. However, that 1991 list of non-exhaustive illnesses that could be serious health conditions should also be balanced by the Department of Labor's list of things that are not serious health conditions, including colds and the flu. It's very clear that Wright's gender dysphoria is much more serious than that list of conditions.
Is depression considered something to leave for something that requires FMLA leave?
Yes, Your Honor. Depression is commonly held to require FMLA leave. In the case Stubble versus TA Systems Incorporated, a father consulting with the physician about his depression over the death of his son was found to require FMLA leave as a serious health condition, even though it wasn't the father's health condition, or rather the son's, that prompted the visit. For this reason, FMLA incorporates serious health conditions including either the employee or the employee's spouse or children. It's meant to balance time between the family and health of a family and the stability of a job. To that extent, it intentionally sets a low
But that was a
bar.
Department of Labor regulation, correct?
Yes.
That's not binding on this court, correct?
No, Your Honor. However, under Chevron deference, since Congress has not spoken directly to the issue, this court should rely on it. To the same extent, the
But they're not
congressional...
medical professionals. We should rely on the Department of Labor about medical issues.
Oh. Your Honor, I see my time has concluded. May I briefly respond?
Yes.
Your Honor, we should listen to physicians about what is a serious health condition, which is why we should honor Dr. G's medical certification that supports that Wright's gender dysphoria is a serious health condition. However, we should look to congressional intent in deciding what a serious health condition might be and what it is not. Here, the court clearly supports that gender dysphoria, in meeting the other prongs of a serious health condition as defined by the FMLA, is a serious health condition. Thank you.
Thank you.
43. We're not actually going to worry about that.